even being a user of TikTok, and TikTok has quickly taken over the internet since its global launch just a few years ago. And this app allows users to create short videos despite being released globally in August of 2018. This is now one of the most downloaded apps of the 2010s. And there's no doubt that TikTok has grown a lot since the pandemic, and it's not a secret that during the lockdown, the use of mobile phones increased and people started using TikTok because it was a simple app to create or watch other creators, explore new hobbies, or just enjoy some tailored entertainment. However, when I make a small survey in my English class whether they know this platform depends on unlicensed songs, then most of them answer no. And this is when the concerns to have heaps of infringement, which is an automatic response then to manage the large volume of original content videos. So what makes TikTok so special? To put it simply, TikTok is no different. TikTok is no different. And there are 4 members in our group. And in our presentation, we will talk about TikTok policies of intellectual property rights, the difference between TikTok policies and YouTube policies, and the last is the cases and litigation related to TikTok intellectual property rights policies. First, let's get into the general overview of TikTok policies of intellectual property rights. Before diving into its policy, first let's talk about what is TikTok. Most of you guys have known about TikTok, but TikTok is a short-form video hosting service launched in 2018 by ByteDance. It's a Chinese company, and this app is a social network focused on vertical video format, where users can upload short videos with durations from 15 seconds to 10 minutes. And any platform with large volumes of organic content would draw a lot of attention to copyright infringement. And it is obvious that most TikTok trends include creators using music in the background of their videos as they lip sync, dance, act, draw, etc. And these creators are able to do this as TikTok has their own library of music for them to use without risking instance of copyright infringement. This is usually music from new or upcoming artists who want to gain exposure. Now let's get into the TikTok policy of intellectual property rights. From the very beginning, you can see that TikTok states that they do not tolerate content that infringes someone else's intellectual property rights and will terminate or suspend accounts if needed. So which intellectual property rights are protected under TikTok policies? First of all is copyright. The term copyright in TikTok intellectual property policies refers to a legal right that protects original works For example, music, videos, and so on, and generally, copyright protects an original expression of an idea, such as the specific way a video or music is expressed or created, but does not protect underlying ideas or facts. This approach is completely consistent with the provisions of Vietnamese law and international law. According to Clause 2, Article 4, Law on Intellectual Property, copyright means copyrights mean rights of organizations and individuals to works they have created or own, and in Vietnamese law, copyright has these following characteristics. Firstly, copyright will protect creative form, not ideas as creative content, and to be protected, the idea must be expressed in a certain form, but copyright does not protect the idea alone, and the creative form must show the novelty by creativity of the work to be protected by copyright. This is also completely matched with TikTok's approach. The second right that is protected under TikTok policy is trademark, and the term trademark in TikTok IP policy refers to a word, symbol, slogan, design, or combination of any of the foregoing that identifies the source of a product or service and distinguish it from other products and services. And according to Clause 20, law amending and supplementing a number of articles of intellectual property law, a trademark is protected if it is a visible sign in the form of letters, words, drawings, image, holograms, or a combination thereof represented by one or more colors or audible signs shown in graphic form. So Vietnamese law has gone one step forward when recognizing audible signs in an object to be protected as trademarks. Now let's get to how TikTok resolve copyright infringement. Copyright law grants an array of rights to owners, including the ability to limit authorized activities. The one way that a copyright owner can protect their original copyrightable material is by claiming that someone who copied the work has committed copyright infringement. And there are two ways to prove a copyright infringement. First is by proving an actor directly infringed the rights of the copyright holder. And secondly is by proving an actor indirectly infringed the rights of the copyright holder by encouraging or assisting a third party in infringing. Each type of infringement is possible on the TikTok platform. First, talking about direct infringement, this kind of infringement may be committed when a TikTok user enjoys a copyright holder's content enough to create a new video of their own using some of the same aspects as the original users. And the same aspects here can be understood that the same choreography, music, or even text, and post them in the original post. However, TikTok has anticipated the issues to mitigate copyright infringement committed by users on their platform. TikTok has included specific language in their user agreement. TikTok states that it does not allowing posting, sharing, or sending of any content that violates or infringes other copyrights. And further, the platform states that the use of copyrighted content without authorization or a legally valid reason may lead to a violation of TikTok's policies. However, TikTok terms of service also state that while the user creating the content is the owner of the copyright on the content, by submitting the content to TikTok, the user grants TikTok a broad license to use the content as well as to distribute and authorize other users and third party to use the content. Therefore, when a user creates posts that use the content of an original user, the original user just retains the copyright in the content, but they cannot sue other users for using the content. And this is a statute allows TikTok to protect its user from direct copyright infringement claims. Talking about indirect infringement, a party may be liable for indirect copyright infringement when it contributes to, induce, or profits from the infringing acts of others. As such, TikTok itself could be held liable when users copy protected works using the company's online platform. However, TikTok has taken steps to protect itself. Although many of the sounds and songs used on TikTok are subject to copyright protection, TikTok has gotten permission to use them. It's entered into licensing agreements with Universal Music Publishing Group, Sony Music, and Warner Music Group, which will allow the songs created by artists associated with those companies to be used on TikTok without the worry of infringement. And through these licensing agreements, TikTok has been able to minimize its personal liability for its platform structure. And TikTok's IP policy states that TikTok does not tolerate with posts that infringe someone else's copyrights, trademark, or other intellectual property rights. Technically, a user can still upload a song to TikTok that isn't in the library, but this runs the risk of the uploaded video being taken down by TikTok. However, there's a funny story. When our group did some research on TikTok, many videos using a song or sound containing unlicensed song are still available. And instead of removing a copyright infringement video, it would just remove the sound of that video. This is because TikTok also has a clause in its policies which states that TikTok may not be able to remove the content or suspend the reported account since it is not in a position to adjudicate disputes between third parties. So that's how TikTok enforces its IPR's policy. Now let's talk about the difference between TikTok policies and YouTube policies. First, about the similarities. Both of their policies have both of their policy protect copyright and trademark, and they both have a clause on fair use exception. And the third similarity is that is in the way they resolve trademark infringement. Let's have a brief talk about fair use. Fair use in U.S. law is a law that allows the reuse of copyright protected material under certain circumstances without getting permission from the copyright owner. However, fair use is determined on a case-by-case basis, and different countries have different rules about when it's acceptable to use material without the copyright owner's permission. In the UK, uses for purposes such as criticism, review, quotation, parody, caricature, and passage might be considered fair dealing, but it can depend on the situation. About the way that they resolve a trademark infringement. Both TikTok and YouTube state that they do not mediate trademark disputes between creators and trademark owners. Therefore, they encourage trademark owners to speak directly with the creator who posted the content in question. And if the owner cannot reach a resolution with the account holder in questions, then he can submit a trademark complaint through these platforms' trademark complaint form, and then the content can be removed in clear cases of infringement. There's only one difference between TikTok policies and YouTube policy that make the TikTok policy much opener than YouTube policy. That is the way they resolve a copyright infringement. And when it comes to TikTok, if there's a copyright infringement, then the copyright owners may submit a copyright complaint to TikTok, and then the TikTok will provide the account holder with the owner contact information, this including the email address and the name of the copyright owner and the details of the complaint. And as I stated before, because TikTok is not in a position to adjudicate disputes between the third parties, therefore, if the owner and the creator cannot reach a resolution, then they will have to assert their rights in court. And in contrast to TikTok, when a copyright owner submits a copyright complaint to YouTube, YouTube will perform a review, and if it's suitable, then YouTube will take down that video. And YouTube also have a mechanism called Content ID, which if there's a match between a reference file and a new upload, then YouTube will let the copyright owner choose a resolution which include to track, monetize, or block the creator. To answer the question why are IPR's policies of TikTok is more open than YouTube, yeah, but I will continue the presentation.
So they have given us a comparison between TikTok and YouTube policies in protecting intellectual property. So we will go to the reason why our IPR policies of TikTok is more open than YouTube. Due to YouTube dominant in the video content space, the platform has published a number of regulations around content use and copyright infringement. This has understandably been an automatic response by them to manage lots of personal content and freedom to share that as you please. So as to TikTok is still subject to copyright laws, but they don't seem to be strict as it's a relatively new platform. In music, there are two types of copyright. First is compositions copyright, which refers to protections of music and lyric of the song. And second is sound recording copyright, which refers to a particular record version of a song. On YouTube, where creators add music to their content without notifying the copyright owners. This often results in right holder requesting that creator delete the videos. Sometimes it even leads to a suspension or cancellations of an account. TikTok is different though. In the beginning, TikTok restrictions were not very rigid at all. Actually, it took some losses of bigger companies in the industry for them to pay attention to copyright issues. At first, TikTok resolved it by banning accounts or deleting videos. But the content going viral damaged banning account. But the com- but the content going viral damage was already done. Artists and labels were not happy with the music streaming worldwide without any form of control. TikTok was accused of not being strict with these copyright policies and was forced to do something about it. But add a new platform and having music and sound in video as the main feature, TikTok had to find out a straight, straightened strategy to attract users and to solve this problem. So TikTok being popular app with the appeal to music for your content had to take action on this. The answer came with a partnership. The company was able to reach several short-term agreements with major record labels such as Sony Music Entertainment, Warner Music, and Universal Music Group. From there, most of indie distributors have followed suit. Ultimately, the deal were a kind of mutually beneficial relationship. Label and distributor agreed to add their product to the app music library for promotion, and TikTok makes sure that right owner receive proper compensation. As TikTok was not originally built around monetizations, video creators do not get any income from their video using copyright music. But TikTok maintains a music library for end users to choose from, and artists get discovered and streamed worldwide. This move of TikTok led to following consequence. First is TikTok agreement with major label allow them to have music within the app available to end user. And second is each time a song is used and played, the owner of the copyright receives the royalty, not the creator of the video or TikTok. And the last thing is creator won't receive a copyright notice. Their video won't be deleted and their account will not be banned as long as they use in-app library. Contrary to TikTok, YouTube app to protect intellectual property. It may block or take down an infringing content, yet it also allows right holder to choose a different option. And first is take down notice. If a copyright owner sends YouTube a complaint, YouTube look into it, and if it find a violation, it take down the infringing content. And the second is YouTube have their content ID match. Content ID is an ultimate system used by YouTube to match original content submitted by content owner against new content uploaded to the site. To use this system, copyright owner who meet specific criteria can upload the original version of their work called reference file that proves their intellectual property rights. In case of a content ID match, your videos on YouTube get a content ID claimed by owner of the copyright protected material. Copyright owners can decide what happened to content that match a work they own. They can block the video in some own territories. They can also allow it to remain monetize. And a copyright takedown include a copyright strike. If a user gets three strike, what the user upload to YouTube will be deleted permanently. There are two types of strike: community guideline strike and copyright strike. The latter refer to video that include content that belong to someone else and is uploaded without permission. So this difference comes from the fact that the way that these two platforms work are different. Since music and video are the main feature of TikTok, in order to maintain the application and attract more users, they need to find a way to overcome the biggest problem posed to these two objects: license. And YouTube revenue comes from many different sources due to the applications of many business models. Meanwhile, TikTok revenue source is somewhat narrow. Therefore, YouTube seems like it does not need to make an effort to build partnership with copyright holders because, in fact, the discovery of copyright infringement has unintentionally created a huge source of revenue for YouTube. Moreover, content creators on YouTube can earn money if their channel meet certain standards set by this platform. Therefore, the strict search for cases of copyright infringement have to clean up the platform to avoid the case of people using the people copyright audio or image for the purpose of making money. And so we have get through TikTok policies, and we have a small comparisons between it and YouTube. And now we will have some copyright infringement cases, and will be presented by Anh Hương.
In a copyright infringement case, music company is including Universal Music, an American global music corporation, have written to use TikTok as the platform or as risk toward copyright law. This is one of the world's largest music company that include artists such as Lady Gaga, Taylor Swift, Billie Eilish, and Elton John. When these songs are used in videos, the artists do not get paid any royalty with data from IP right. As a result, Universal has tried to negotiate deal with TikTok to enable use to use the protected music while volunteering the artist with financial benefits. Music publishers over in Europe face similar issue. In 2019, International Copyright Enterprise called ICE, a joint venture representing the digital music right to collective society PRS for music in the UK, GEMA in Germany, and STMI in Sweden. Enter into licensing negotiation with TikTok when the party could not agree over the music license. TikTok moved forward by taking the dispute to the UK Copyright Tribunal. Um, the Swiss copyright guideline could explain why TikTok withdrew from the tribunal and moved to enter into an arbitration agreement with ICE. Copyright laws in the UK use the fair dealing doctrine with list specific exceptions for using copyright material and provide that if a user does not fall under list exception, it be an infringement. After that, both party release a joint statement mentioning the term of the agreement include retrospective payment for the under license use. Another case, the company in Vietnam called VNG, they filed a lawsuit against TikTok to request a removal of all music segment set from Zing records, as well as in identification for damage of over 221 billion Vietnam dong, about 7 million pounds. They believe that this IP infringement caused damage to the company as an estimated total of 150 Zing records were used in more than 11 million videos despite the copyright laws in place. This was because TikTok did not have sufficient listen to use the song, nor did they ask for permission from VNG. This also poses a question to whether users are aware that their video may contain songs copyrighted by music companies. The Vietnam Musical Association states that TikTok avoid having to comply with copyright regulation by offering very complex business model. Other issues, TikTok believe that they did not break IP law and refused to remove the song on the platform. So far, the lawsuit between VNG and TikTok has not been resolved. Through the above case, it can be seen that TikTok often does not admit to infringing on intellectual property rights. The platform often tries to negotiate with the rights holder, and only when no agreement is reached does TikTok compensate them. About the conclusion, firstly, when it comes to the request to the question whether TikTok has policy on IPR, the answer is yes. However, when taking a closer look at this policy, it can be seen they are that TikTok can employ to benefit themselves. In condition, TikTok term of service may also be unfair to the original user when it states that by submitting the content to TikTok, the the user grant TikTok pro license to use the content as well as to distribute and authority or the user and third party to use the content. Secondly, TikTok policy are often commented on as being very open when compared to YouTube. This can be explained not only because TikTok is a new platform, but also because the way TikTok and YouTube operate differently. This was analyzed in part 2 of our representation. Finally, as mentioned about, although TikTok stay in their policy that it respect the intellectual property rights of others, the way TikTok resolve dispute over intellectual property right does not really show that. Although TikTok has successfully avoided many claims of copyright infringement using agreement and license, there are still some instances of infringement that may slip through the crack. As such, TikTok is not completely shielded, and neither are their users. Therefore, it is important to be cognizant of many intellectual property protection associated with potential social media and address them before posting the material to avoid any possible repercussion. Thank you for attention. Any question, please raise your hand.
Right, time for question. No? Question video. Yeah. No question. So anyone have a question for your group? So, any questions so far? So, first of all, thank you for your presentation. I have a small question for you, Proof. Is now you answer the question to conclude that TikTok have an open or closed policy on IPR. Okay? Close or open policy on IPR. And also, Hưng already mentioned about before they go to compensate, they normally negotiate, right? Bargaining with a copyright owner. So what is the purpose and what's the future of TikTok? Alright. Như vậy thì qua những cái phần trình bày bây giờ nhóm có kết luận lại là khi chính sách TikTok thì đóng hay mở này. Và lý giải tại sao nó còn có những trường hợp vi phạm đang xảy ra TikTok. Và từ đó là dẫn đến câu thứ hai thì như vậy để giải quyết thì họ thường negotiate với những người intellectual property holder. Như vậy thì tương lai TikTok là như nào này? Yeah. That's a good question. Okay. So by the time you are thinking about the question, I will summarize some content. Khi chờ đợi nhóm trả lời thì thầy sẽ tiếp tục hùng cho em tiếp những cái nội dung tiếp theo. So we go through this syllabus and we already covered some question about intellectual property, some matters of the copyright, and today the fifth section. We stay here in copyright, and then for the next group, group 4 or 5, you choose a question from the syllabus, or you can contact me if you have any other subject or the new matter of presentation. Okay. So today we will move to a chapter that's the economist right and the moral right. Economist right and moral right of the copyright. Bây giờ ta sẽ đi tiếp cái nội dung là cái economist right and moral right. Cái nội dung này em nghiên cứu về pháp luật của Việt Nam các bạn. The first part is about an overview of the IPR. So you already study about the characteristic of those rights. And now we move to the content. The second is about the justification of the IPR. You understand that there's monopoly to protect the author and the owner. And also they need to balance with the social interest. Okay? So, next part is about the content of the copyright. So we have the economist right, and we have a moral right, economic and moral right in copyright. Như vậy cái nội dung của copyright thì em đã học qua đấy, chúng ta sẽ có quyền nhân thân và những quyền về tài sản, nhân chất, nhân thân những quyền về tài sản. Vì tài sản thì gọi là economic right, quyền nhân thân thì gọi là moral right. Okay. So the seminar called economic right grants the copyright owner the law governing the infringement of the right. Okay. So we also see the nature of right granted under copyright law. So as soon as we study about the comparative law, that's meaningful to see the UK law. I highlighted in this syllabus, CDPA 1988, a negative right. That's the right to certain act being performed in relation to copyright work and the act restricted by the copyright here. And how we call a negative right? Because this right born to restricted the third party to embrace the copyright law. One of the reasons we call that a negative right. Vì sao ta gọi là cái negative right? Thì cái quyền này sinh ra để làm gì? Ngăn cản những chủ thể khác những hành vi xâm phạm, đúng không ạ? Và trong cái economic right này chúng ta thấy là những cái quyền lợi kinh tế, quyền lợi tài sản ấy. Thì first we see the copy, to copy the work, quyền sao chép. Có một cái tác phẩm ta sao chép và ta bán, hiểu không? Kinh tế là như vậy. Còn về tài sản là những cái quyền gọi là được đặt tên đứng tên đó, quyền về giá trị tinh thần. Ở đây là quyền ta xem quyền tài sản. It said that the issue copy of the work to public, the rent, the land, the work to perform, to communicate, and to make some adaptation. So this right we call the economic right. Okay, economic right. So for the right of the copying, So according to different kind of work, we have different behavior. For example, for literary, dramatic, and musical, artistic work, copy in relation to literary means reproducing the work in any material form. Okay, and this includes storing the work in any medium by electronic means. All right, copy. Như vậy cái quyền sao chép tác phẩm em thấy cho tác phẩm văn học, nghệ thuật, âm nhạc này kia, đúng không ạ? Thì đó là cái định nghĩa là cái việc tạo ra tác phẩm bằng bất kỳ cái phương tiện nào, hình thức nào, đúng không? Kể cả cái việc mà chúng ta show, save, storing, chúng ta lưu trong máy đó thì cũng gọi là cái hành vi gì? Sao chép, reproducing the work. The statute also provide further guidance on the meaning of copyright, copying in this case of certain form of work. For artistic work, a dimensional shift may infringe. So we have two-dimensional work, two-dimensional work or three-dimensional work. Những loại tác phẩm nằm trong không gian 2 chiều, 3 chiều. Tiếp theo là những tác phẩm gọi là phim hoặc là những cái broadcast phát sóng. The copying include making a photograph of the whole or any substantial part of image, forming a part of film or broadcast. Alright. So the action we take photograph also considered like copying. Okay, the thing you need to pay attention. In the case of any form of work, so copy include making copy which are transient, incidental to some other use of the work. So that's the case. Reproducing and work. Besides the reproducing and work, we have the right of distribution right. And when we want to communicate work to the public, communicate the work to the public. By the rights, we have right to make some money on that point. Okay. And in the UK right, we also have some principle we call exhaustion of right. Cái exhaustion of right này giống như là cái lý thuyết về cái cạn quyền các bạn ha. Cạn quyền. When the work is first sell to the market, we expire the right, and that's we call the exhaustion of right. Okay. The next one, renting land work to the public, performing, showing, or playing the work in the public. All right. Communicate the work to the public. Adaptation. Adaptation. So we have something we call adaptation of the work. That means we translate work from different languages. Translate, and we just call the derivative work, the different type of work. Also, the computer program have been protected by the copyright database musical work. Okay? All right. What about the infringement? First, we need to prove the causal connection between the copyright infringement. Some action can be indirect or direct. So let's see some case law. If you have time, or if you do a project of scientific research, you can cite some jurisprudence to prove your argument. Okay. So further reading for that. Okay. And that's the economist right. So I have go through the economist right. Okay. So you can see that economist right, that's concerned to the act of reproducing the work. Okay. To communicate the work to the public. This we call the economist right. And now we will move to the moral right. So what is the moral right? Moral right. What is it? Moral right, what is it? Gì? Vì nhân thân, đúng không? So, different to the economist right, we have moral right. The moral right is some right attached to the person. So they protect the author rather than the copyright owners. Okay? So unlike the copyright, moral rights are not property rights. Yeah. And they're based on the civil law jurisdiction. Civil law jurisdiction. So from the World Convention, you can see that the moral right they performed by the right of attribution and the right to object derogatory treatment, integrity right. Okay, and also we confirm by the TRIP agreement. However, there is difference between the common law and civil law system for the moral right. Some countries they have a dualist system, and some countries they have a modalist system for the moral right. So who hold the moral right? Here we can see that statutory moral right are granted to author of the copyright, literary, dramatic and musical work, moral right. Như vậy quyền nhân thân sẽ gắn với những cái cá nhân nhiều hơn, đúng không ạ? Bây giờ mình đi xem cái duration of moral right. The right to full attribution last for 10 years after the person's death. The right to be assert. So just go through this. The right to object derogatory treatment. Called the integrity right. The right to full attribution. right to privacy. Yeah. And in the civil law jurisdiction, we can mention about France and Germany. The moral right of author extend beyond the right described above. Also, moral right and the right of divulgation of work in the right of retraction. Okay? So we see some case law on that time. Case law on that moral right. About Vietnam, we have the intellectual property law of Vietnam. We have the same approach of the copyright, but because Vietnam is follow the civil law system, so they're much more similar to the France and Germany. So they also divide the copyright into the moral right and the economic right, what we call the property right, economic right. So from the moral right also we have the name of the work, with the real name, protect the integrity of the work. And for the economic right, that's the right to make derivative, perform, reproduce, distribution, broadcast or rental. Economics right. Okay, so that's the Vietnamese law. And so clear that. Như vậy thì trong luật Việt Nam tụi em đã học rồi thì họ cũng phân chia như vậy nha. Gồm có quyền nhân thân và có những quyền về tài sản, đúng không ạ? Gọi là economic right, nhân thân, có những quyền về tài sản. Besides that, we have some exception. Copyright exception, Article 25 of Vietnamese law. When some action fall into this exception, this action is not infringe the copyright law. Okay. So, for example, the sell copy for one copy for personal study and research, original copy, using work in official activity or state agency, a reasonable sign of the work without misleading of the work or comment, introduce or illustrate in his work, using work in library activity and on commercial purpose. So those actions we have an exception. So why, my question is why they need to have some those exceptions like that?
Limit a copy, limit some people use the copyright to prevent someone who try and research and post his work, share the work for everyone. I think so.
This exception, they confer the right to the author or the user. Confer that right to the author, user, right?
Yeah.
And the user represents the society.
Yeah.
Common interest.
Yeah.
And we move to the second justification of IPR. Still remember? What we need to protect the author and the owner. And another way we need to balance to social interests, right? And to balance to social interests, we use this exception. So you get that?
Yeah, I get it.
So the economists, right, they prohibit people to copy, to present the work to the public. Whether the copyright exception, they prohibit those actions. And the exception, they open this. Okay? So they allow students to have a single copy for personal study or research. Right? các em hiểu cái điều khoản ngoại lệ này không? Ngoại lệ này để làm gì? Nó để là justification đấy, tức là gì? Để cân bằng cái
giữa cái người tác giả và người dùng.
đúng rồi. Nếu người ta bảo vệ nhiều quá nó gây tình trạng monopoly độc quyền, đúng không? Người ta phải cân bằng lợi ích của gì? Xã hội. Và để cân bằng này họ sẽ đưa ra những ngoại lệ. Ví dụ như là những economic right đâu có cho phép các em phân phối tác phẩm đâu, đúng không? When you use the economic right, they not allow you they call negative right. Negative right. It doesn't allow you to reproduce or photocopy the work to the public. Okay? Because by that's why they make money. Okay? They reproduce the photocopy the work, sell to the public. To make money. To make money. So in order to balance the interest, they create some kind, as we call an exception. Okay? In Article 25. So instead of they prohibit some act against its economic right, but they still allow students to reproduce the work. Okay? So in that way they have allowed self-copy for personal study to serve for that purpose. We call original. So that's why we have exception the copyright they allowed. But they're not allowed freely, and they need to respond to certain kind of criteria, condition. The first one, not affect the normal exploitation of the work. The second is without prejudice to the right of the author. Okay? And last one is must have information about the author name and origin of the work. Okay? They're not open freely, but they need to focus. They need to have some kind of condition, and we can count that first step, second, and third step. That's why we call that the three-step test in the copyright. Alright. Như vậy nếu mà cho em photo miếng thì họ đâu kiểm soát được. Họ phải đưa ra cái điều kiện, đúng không ạ? Cái điều kiện này gọi là phép thử cái gì đây? Nha. Mình thử mấy bước. Mình thử lên đây bước 3 bước xem. Mấy bước gì? Hả? Bước gì? Bước thứ 3 bước. Bước 3 bước.
Nó là trường hợp đặc biệt không làm phương hại đến sự khai thác bình thường,
Rồi, gì nữa?
không làm ảnh hưởng đến quyền hợp pháp của tác giả.
Đúng rồi. Three-step test. 3 bước. Như vậy mặc dù cho các em photocopy nè, ai phát biểu tự ghi điểm 1 cộng cho nhé. Cho phép photocopy, ok. Nhưng mà gì đâu phải là cho phép photo em đi bán này gì chết người ta.
Nói chung là
Đúng
không
không?
có tiền bạc.
Cái gì?
Không có yếu tố tiền bạc được.
Không có yếu tố thương mại,
Không.
không được phổ biến ra nhiều, đúng không? Personal use. Bản chất của tác phẩm là gì và cái gì? Proportion. Cái số phần trăm, ví dụ quyển sách photo hết của người ta thôi chứ. Chỉ được photo một gì? Số lượng trọng nhất định. Thì đây nó gọi là phương pháp gì? Hả? Pháp gì bạn nghe? Phương pháp 3 bước thử, 3-step test. Okay. That's allowed to control copyright. Okay. So you can see the introduction. So read that. Okay. Even where claimant can make out a prima facie copyright infringement, a defendant may still escape liability if activity fall within the scope to one of the defenses available under the copyright law. Okay. So như vậy sẽ tồn tại nhiều cái hành động reproduce the work, nhưng mà gì cũng không là hành vi xâm phạm nếu nó rơi những trường hợp ngoại lệ. Chỉ ngoại lệ hoặc là những trường hợp gọi là defenses, hoặc là những cái defenses. Defenses that mean exception. Okay. A statutory defense of permitted act. Ba cái thuật ngữ mà em cần nắm nhé. Exception, similar meaning to defenses and permitted act. Những trường hợp ngoại lệ, những trường hợp gì cho phép, được phép. Ok. Thì trong những cái này có một các nước sẽ sử dụng những term nó khác nhau, nó chẳng qua những cái ngoại lệ đó, những trường hợp ngoại lệ như vậy. So the purpose why they have this exception line I explained to you, that's certification for IKEA. They need to promote social interest, education, promotion of some social activity. Okay. Because when they restricted you to photocopy a work or books, you don't have some document to study. Okay? Some people don't like to read on the computer. They normally print out the work. For example, me, I am very lazy. I rarely read on the computer. So I normally print out or make a photocopy. Because when you print out a book, you can highlight, okay? Can memorize the word very easy, okay? Right of reproduction. So if you restrict the people to just copy, and then society cannot advance, you need to open. So that's why they open this exception, okay? So we move to the European legislation. From the European legislation, we have the InfoSoc Directive, which I told you before, InfoSoc Directive, the Information Society Directive. Member states are only allowed to retain exception covered by the list of permissible exception and limitation. Okay, this directive proposed that's the position, and then every member state of the European they will transform into the national law. Okay. So what about the three-step test? They need to comply with the InfoSoc Directive, Information Society Directive. Exception limitation provided by RAP so only applying certain special cases. Yeah, I already mentioned about that. Special cases. That means for education or private purpose. So they call them special cases. Not all the cases. For example, the photocopy shop, photocopy store outside, the photocopy service, they're not falling into the special cases because they photocopy for commercial purpose. The second, they do not conflict with the normal exploitation. Like you mentioned, they cannot infringe to economic things. If they photocopy and they sell with a massive things, and then they will not support the normal exploitation. And lastly, do not unreasonably prejudice to the legitimate interest of the right holder. Okay, so that we call the three-step test. And the three-step test originally applied in the Berne Convention. From the Berne Convention. And from the Berne Convention, they will integrate to the national law of United Kingdom, also in Vietnam. Because Vietnam and UK is a member of the Berne Convention. Berne is the city of
Born in the city of
China.
Germany.
China.
Switzerland.
Yeah, yeah.
Oh yes, Switzerland.
Yeah.
I know it. I knew it.
Can I song?
Pardon?
Can I see the song practical again? More.
Yeah.
Còn lần xíu nữa thằng quyết nó
No exploitation of the work. Okay. You can find that easily at Article 9 in the Berne Convention. Okay. But copyright work. Okay. So the statutory permitted act, and I told you permitted, that means exception. Okay. Similar meaning. Exception or permitted act. So please be aware of the range of permitted act under the CDPA 1988. However, you are only expected to have a detailed knowledge of discussion below. That means that some people call us three-step test is fair use or fair dealing. According to US law, we use the fair dealing, fair use. And the UK law, we use the word fair dealing. That's why I say comparative law very, very complicated. It's not very easy when you try to understand the term, okay? Very, very massive. Different legal terminology. So I have spent many years, or 6 years, in order to understand just the legal terminology, very, very complex, complicated. Đó lý do cái luật so sánh nó rất là khó đó các bạn. Để hiểu được một cái term nó mệt. Đấy. Mỗi nước nó sẽ chịu một cái term khác nhau. Ví dụ cái fair use mình chịu hợp lý mà. Khi đi vào pháp luật quốc gia để trở thành là exception. Và khi đi pháp luật của Đức thì nó gọi là permitted act. Qua pháp luật của Anh thì gọi là fair dealing. Nhưng qua pháp luật của Hoa Kỳ thì gọi là fair use. Nó là fair dealing.
rồi cái này đúng.
Tất cả là đúng.
Vậy tới cái gì này?
Chỉ là cái phạm vi khác nhau.
Có thuận công bằng.
Giao dịch không bằng. Đấy, và thực chất là cái exception in Article 25 of Vietnamese Intellectual Property Law. Okay. Đấy, so sánh pháp luật là nó như vậy. Nhiều khi mình đọc biết mình không có tìm thấy cái term ở trong cái pháp luật quốc tế. Mình nói là pháp luật quốc tế không có. Do nhưng thực chất không phải là không có, mà nó có từ ngữ gì? Tương đồng. Tối hôm qua có một nhóm viết bài cho tạp chí, sinh viên khoa pháp lý hỏi thầy viết cái bài về terminology, legal terminology. Khi mình dịch cái thuật ngữ pháp lý vào các nước thì nó sẽ rất là khác nhau. Không phải lớp mình không nè? Không phải. Không phải học legal English. Như vậy là cái terminology của các nước nó sẽ rất là khác nhau khi mà đi vào pha pháp luật quốc gia. Thì nó sẽ khác nhau. Đấy. Three-step test. Rồi thì về three-step test thì có thể chúng ta dừng cái này đi, nhiều nội dung quá. Các bạn về đọc thêm như thế nào không hiểu thì hỏi thầy nhé. Ok. Rồi về nhà chúng ta suy nghĩ thêm sao cái bài này chứ chưa về. Tôi suy nghĩ thêm là what are the dangers of three-step test for development of copyright exception? Okay. And the second question is either three-step test are necessary protection of the copyright owner or unjustified restriction on the freedom of user. Okay. Cái nhóm thảo luận tiếp theo có thể làm cái câu hỏi này nhé, có thể làm một bài present về cái này, rất là hay nhé. Nhớ nha, là theory 3-step test là gì, trong bên là gì, pháp luật quốc gia các nước là gì, có thể sử dụng lại những cái tư liệu hồi nãy giờ thầy đã nói nha. Nhóm đó tiếp theo là nhóm nào vậy? Nghe phải không? Có làm được không? Làm được không? Và những cái case law đưa vào justify, trả lời hỏi xem suy nghĩ có làm được không nhé. Alright, so that's all for today for this lesson.